I'd like to call this meeting of the Grange Zoning Board of Appeals for Monday, March 2nd, to order. The first item of business is review and acceptance of minutes from our previous meeting. Does the board have any additions, comments, or corrections to those minutes?
No.
I'll take a motion to accept.
So moved.
Second. All in favor?
Aye.
Excellent. We'll move to our order of business. This is a public hearing regarding Mr. Tellini, or actually several Tellinis, in regards to an interpretation of Town Code Section 240-31, which is essentially the section which covers special overlay zones. In particular, I believe we're interested in paragraph F, and that his parcel is not subject to the essentially restrictions designated as a reflex protection overlay zone. Given that, I'll take a motion to open the public hearing.
So moved.
Is there a second?
Second.
All in favor?
Aye.
Okay, at this time, I would like someone to come forward to present this application.
Good evening, Mr. Chairman, members of the board, Ms. Vaught, Ms. Hughes. My name is Mauricio Tellini, and I am the attorney for the applicant. Before we begin, these display, would you like them facing you?
They should face us,
Okay.
because after all, we have to be the ones to see.
We're gonna have hand-ups of these, they're just smaller,
Okay.
so I leave it up to the board to
By
discretion.
by procedure, we should look at this should be facing us.
Okay, yeah, they can turn them right there where even the audience can see as well, like there's fine.
Yes.
Yeah, that's fine. And if you need to like bring it up, you can bring it up and show it. Yes, fine.
Just by way of background, in addition to being an attorney, I have over 30 years of civil engineering experience. I also have the unique privilege this evening of being an applicant, as well as one of the co-owners of the subject property. The property is a 23.7 acre parcel located at 2546 Route 82 in the hamlet of Billings. On information and belief, the subject property is located within the RLD zoning district and agricultural district 22. Our family purchased this property back in 1973 from Carmelo, also known as, for those of you from Billings, Scott Stagliabeni and his wife Catherine Stagliabeni. And we have owned and maintained this property continuously for 53 years. How are we going to handling up exhibits? Are we going to have a system of numbers?
You can number them either 1, 2, 3, ABC as you're referring to them, whatever you
Does the
prefer.
board have a?
We'll use your system of indexing, whatever is convenient.
Okay. Sorry about this.
No, appreciate it.
Thank you. You can pass mine down so that. Oh, is there enough?
I think there's enough.
Oh, all right.
I handed out 8 copies.
Okay, yep.
These photos are historical photos. I'd like to introduce those into the record. They depict ownership, use, and stewardship across generations, again, for the last 53 years. My mom got these photos for me. Perhaps you guys can figure out which one I am. Tonight's application seeks to appeal the determination of the zoning administrator dated January 28, 2026, and also seeks an interpretation of this board to resolve uncertainty that exists in the exact boundaries of the Ridgeline Protection Overlay Zone pursuant to Town Code 240-31A5, which reads in pertinent part, in the event of uncertainty as to the exact boundaries of any overlay zone, the Zoning Board of Appeals shall interpret this chapter by designating the exact boundary pursuant to the criteria established below for creating each overlay zone. Mr. Chairman, in the interest of brevity, we're going to be mentioning Ridgeline Protection Overlay Map and Ridgeline Protection Overlay Zone and Code quite a bit tonight. Can we use like a shorthand?
Certainly.
Okay. It's just going to make it a lot.
We could basically short it to the zone versus the map.
The Ridgeline Map, Ridgeline Zone,
Yep.
Ridgeline Code.
Yep.
Okay, fine. With us tonight, we have Andrew Bolton, an engineer at Podgy Engineering located in Fishkill, New York, whom will testify after my overview. Mr. Bolton will provide expert testimony regarding number one, determination of the relevant data points pursuant to this application, and two, New York State education law as it pertains to this application. The applicant's presentation can be categorized into three major parts. Number one, analysis of the Ridgeline Code history. Number two, analysis of the Ridgeline Code. Number three, analysis of the Ridgeline Map, including expert testimony. So let's begin with Ridgeline history, the history of the code. Some key milestones. June 28, 1998, town passed a resolution, local law 1998-1. July 27, 1998, town filed local law 1998-1 with the New York State Secretary of State. October 5th, 1998, town filed local law 1998-1A with reference to Map A. In 2006, the town completed a renumbering which reclassified Section 100-31 overlay zones to where it sits today, 240-31 overlay zones. The code was amended several times over the next few years regarding small details such as definitions, including hilltop, ridgeline, and ridgeline protection overlay zone. Pursuant to A4, the provisions of this section shall take effect only if, as and when, each overlay zone created herein has been referred to a specific map. Due to this section of code, the town was required to adopt a map which would be introduced 16 years later after the initial 1998 filing at the August 4th, 2014 special town board meeting, followed by a public hearing September 10, 2014, where the town board passed a resolution adopting the Ridgeline map amongst other maps and codes. On September 15, 2014, local law 2014-4 was filed with the New York Secretary of State, including a map listed on Appendix G. I would like to enter into the record a copy of the official map filed with the Secretary of State. I guess we're going to call this Exhibit 2.
Sounds good.
Mhm.
I think we should go around this way. It's just
Yeah.
Do I have one? This is the official map filed with the Secretary of State. Upon information and belief, we have been advised by the Secretary of State, staff, and archives that this is the only ridgeline map filed, and that no other ridgeline maps have been filed with the New York Secretary of State, including the aforementioned map A. That's a little bit of the history of how we got here. An analysis of the code. I need to address the effective date of the code. As previously mentioned, 240-31A4 provides the provisions of this section shall take effect only if, as, and when each overlay zone created herein has been referred to a specific map. This code could not have been effective because no map was adopted until 2014, when the board passed local law 2014-4, where the resolution stated, establishing the ridgeline protection overlay zone. But it should be noted that the document filed is titled Ridgeline Protection Overlay Zone, contrary to the name identified throughout the numerous parts of the Ridgeline Code. So, the title of this document is Ridgeline Protection Overlay Zone. Your code, in numerous parts, refers to it as the title, Ridgeline Protection Overlay Zone Map. The names are different. Section 240-3185 states, in the event of uncertainty as to the exact boundaries of any overlay zone, this zoning board of appeals shall interpret this chapter by designating the exact boundary pursuant to the criteria established below for creating each overlay zone. So the town board, in its wisdom, granted this board the power to designate the exact boundary of any of these overlay zones. This very section of code is why I'm in front of you tonight. Here it describes your role to designate the exact boundaries according to the code established below, being the Ridgeline Code, not the definition set forth in section 240-112. Let's talk about the definitions. Section 240-112 contains 3 definitions relative to the Ridgeline Code, which were adopted as an amendment post-filing of the initial 1998 law. Hilltop is defined, quote, an area of higher elevation as designated on map A, included as part of this section. Number 1, the definition is overly broad. We don't know what an area of higher elevation is. It's not defined. Secondly, the reference to map A is moot, as map A was never filed with the Secretary of State. It does not exist. The second definition, ridgeline, defined as, quote, a portion of a hilltop as designated on map A, included as a part of this amendment. This definition is also overly broad. A portion of a hilltop does not delineate the size of the portion, the elevation of the portion, or anything else related to the portion of the hilltop. The issue here is that this is a broad definition utilizing an already overly broad definition. So we have an overly broad definition that already uses another overly broad definition. It's overly broad on top of overly broad. Again, the reference to map A is moot, as map A was never filed with the Secretary of State. the last definition, ridgeline protection overlay zone. Quote, see attached map A, included as a part of this amendment. In general, this map was developed using the following criteria: an area of a hilltop or ridgeline, which is measured from the highest point above mean sea level on the hilltop or ridgeline to a distance of 200 feet below the highest point. This definition does not define anything. Rather, it mildly discusses the method used to develop the map that may not even exist. Quite frankly, map 8 does not exist. And on top of that, the criteria listed in this definition does not even match the criteria listed in the actual ridgeline code. Yet again, the reference to map A is moot, as map A was never filed with the Secretary of State, according to their archives department. The actual ridgeline code and the criteria for this zoning board, that this zoning board is required to utilize, describes the method used within the boundaries section of section 240-31F2, which reads, quote, boundaries. The ridgeline protection overlay zone shall consist of all lands labeled as ridgeline protection zones on the ridgeline protection overlay zone map, which is included as a part of this section. Here's the key. This is very important. The method used to determine the boundaries of the ridgeline protection overlay zone, as shown on the map, is as follows. Any hill with a USGS elevation of 500 feet or higher at the highest point is classified as within the ridgeline protection overlay zone, the boundary of which is 200 feet in elevation below the highest point of the hill. Any hill is not defined in your code. USGS elevation of 500 feet or higher at the highest point, however, is a precise term. Is classified as within the... Two more things regarding the issues of the code. The USGS applicability and the ability of the county to apply the code. First, on the USGS.gov website, there is a disclaimer. I'll read the disclaimer. USGS topographic maps are general reference publications and can't be used as legally authoritative sources for boundary information or litigation. Thus, the code should not have utilized USGS for legally determining boundaries, ironically, nor should it have used for this discussion. Yet we are here. Part 3, analysis of the map. With respect to Part 2, analysis of the ridgeline map, the task can be further divided into two categories. Map analysis, testimony from the expert. Let's deal with map analysis first. I'd like to point to this map on the wall. The map on the wall, before I do that, I have a handout. We'll call this Exhibit 3. next one. Two pages. These are photographs of this map. This map was created on December 6, 2000, revised September 30th, 2000 by Chazen. I want to turn to page 2. It's highlighted for you. This map is a product of the Chazen companies. Here's the key language. It should be used for reference purposes only. Reasonable efforts have been made to ensure the accuracy of this map. The Chazen company expressly disclaims any responsibilities or liabilities from the use of this map for any purpose other than its intended purpose. This map was created for reference purposes only. That's what I want the board to gather from this. All of these maps were for reference purposes only. They do not have the force of law. In addition, we'll go back to page 1. This report by Chazen Company bears no official seal of a New York State licensed design professional. None of these maps have any seal from any surveyor, engineer, architect, geologist, any design professional whatsoever. No seal. Hence the disclaimer that these maps are for reference purposes only and do not have the force of law. There is an online map, which I neglected to print, but it's on the town's website. It doesn't look like this. This version of the Ridgeline map, published and available to the public online, again bears no official seal, and more importantly, it is not identical to the map filed with New York State attached to Local Law 2014-4. So, just to recap. This was the map filed with the Secretary of State back in 2014. This is the official map on record with the Secretary of State. The map that's available online on your website is not this. Regarding, back to this file map, which is Exhibit 2. I want you to take a look at the map. There's a few key words on the map. It says draft in 3 different places. Suggesting the map is not official. It says draft. In addition to this map, the highest points are not delineated anywhere. Does anybody see the highest points?
You're making a presentation, it's not a question and answer at this time.
The boundaries defined in the code as 200 feet below highest points are also not delineated. USGS elevations are not to be utilized as previously referenced and disclaimed by the USGS. And the applicant believes that, in fact, USGS elevations were not even used as described in the code. Rather, some other data source may have been used for these elevations. Most parcels affected by this map are not visible or identifiable on the map. If you owned property and you wanted to see if you were in the ridge line, you cannot tell from this map where the parcel lines begin and where they end. It's all blacked out. This denies the ability of property owners to identify their parcel. This would deem the adoption of the map to be invalid. Just so we're clear, this is the only map filed with the Secretary of State. All other maps should be disregarded and inapplicable to any fact finding in this board's decision. This is the only map. Possibly the most fatal flaw to the filed map itself is that it bears no official seal from a licensed professional, ensuring that the public and the board as to the map's accuracy and reliability. We put seals on documents to give the public assurance that there's a licensed professional standing behind any document's accuracy and validity. These maps bear no such seal. We do not know if they're accurate because there's no seal from a licensed design professional. Because the map lacks any countable data nor boundaries, leading one to assume that the adopting board could not have verified its accuracy, such an official seal is relied upon to assure the public of its validity. Our expert witness will provide further insight into that particular item. At this point, I'd like to call up the expert.
Good evening, everybody.
We're going to have to share the mic.
Okay. Yes.
Please state your full name.
Andrew Lawson.
What do you do for a living?
I'm a civil engineer.
Where do you work?
Project engineering in the district.
What is your title there?
Project engineer.
How long have you worked there?
Like 4.5, 5 years.
Where did you go to school?
I went to RPI in Troy.
For the record, I also went to RPI in Troy. Do you have any advanced degrees?
Yep, I have a Bachelor of Science in Civil and Environment.
Does your firm specialize in any particular field?
Yeah, we do work mostly civil, environmental, municipal work.
In your professional capacity, have you provided engineering services on behalf of any local governments?
Yes, multiple in the region.
During the course of your career, have you had to work with USGS maps and/or reports?
Yes.
Can you explain the type of information that is contained in USGS data sources?
Yeah, so the United States Geological Survey just has a bunch of physical information depicted on maps, so boundary information, topography, and then above ground features, water bodies, above ground features being, building locations, road locations, that kind of thing.
With regards to your work with local municipalities, have you developed or analyzed land use plans, zoning maps, or zoning codes using the information contained within USGS data?
Yes.
Has your work been peer reviewed?
Yes, all civil engineering work is.
Have you testified in front of any municipal boards before?
Yes, several on the Hudson Valley.
Did I ask you to review materials related to our application before the zoning board today?
Yes.
Did you review those materials?
Yes.
Are you prepared today to tell us what you did, how you did it, and what conclusions you reached?
Yes.
Did you prepare a report for this application?
Yes, it's limited to a couple of exhibits. I don't know if you want to address that.
Yeah, let's hang.
And,
This would be exhibit 4.
I think you're right.
Let's see, yeah. No, just looking at it.
Okay. It seemed like he was reviewing. I didn't want to interrupt.
Oh, no, sorry.
Please explain the material you reviewed in creating your report.
It's just material from the town code, including the attachments that are on publicly available, USGS mapping, and yeah, personal information.
Can you identify the subject parcel, can you identify the subject property parcel lines on the town's filed map?
That would be exhibit 2.
On exhibit 2, excuse me.
Yeah.
Let me clarify that question. Can you identify the subject property parcel lines on exhibit 2 already submitted into the record?
You can't identify all the subject parcels property on the exhibit.
Why is that?
It's shaded over.
After you completed your report, did you arrive at a conclusion?
Yes.
Outline the specific facts and data that you relied on in coming to your conclusion.
So again, it's just the publicly available information from the town, and then elevation data from USGS, as well as an analysis of that topographic information from USGS. So, identifying points of interest for the.
Did you identify any boundary criteria as set forth in the town code?
Yes. Right.
When coming to your conclusion, did you rely on specific scientific or technical principles or methods widely used in your field?
Yeah, so USGS is kind of the standard that we use as kind of starting point, and then we use things like ArcGIS and Autodesk industry standard programs to analyze maps, base maps of that kind.
So specifically, the tooling was ArcGIS and Autodesk?
Yes.
Okay.
Do you believe, is USGS data used in your daily activities?
Yeah, like I said, it's kind of the industry standard from kind of like a starting point, essentially. so.
Do you believe your testimony will assist the zoning board this zoning board to understand the facts of this application?
I hope so.
Mr. Chairman, at this time, I tender this witness as an expert in the field of civil engineering and geospatial information systems, including USGS elevation data.
Okay, so first of all, this is not a courtroom where an expert witness has to be formally certified by the court.
Okay.
The board is permitted to rely on the weight, and I suspect, given that you've had this testimony, the board is going to want to have the town's consultants weigh in on this as well.
Yes, and since we're recording all of this, we are able to do that.
Yes, we'd be able to share the recording with them.
So I'll stipulate that, in reference to.
You acknowledge that he's offering it for that purpose, but we're not stipulating as to any
Does
expertise.
he fall within, under the affidavit that the applicant signed in regards to, whole truth, not, perjury, that sort of stuff?
Yeah, I mean, any witnesses who are testifying, it's presumed that all testimony is going to be under, because it is an administrative proceeding, so it does require essentially an oath and truthfulness to the testimony.
Okay.
Do we have to administer that oath?
We typically do not administer the oath for each applicant. Some ZBAs do that. You can administer the oath if you wish, and he can essentially reaffirm his testimony if that would make the board comfortable.
And because what we had done is we stipulated that upon signing your, affidavit of ownership and whatnot, there is a clause in there that, it is truthful, et cetera. I'm willing to accept the fact that since you signed that, document, that your signature will also apply, to your witness, and that he would also be bound by the same conditions that he's giving truthful testimony.
Okay, Mr. Chairman, fine. Next question. Do you create maps or reports in your daily performance?
Yeah, that's pretty much all of it.
Do you include in the Article 145 warning on every official report provided by the firm?
Yes, that's the more into the mic. Is this better?
Yeah.
Sorry about that.
I don't think there's been a foundation as to what the Article 145 warning is.
That's
Yeah, thank you. Everyone could kind of speak into the mic,
Okay.
thank you.
What I'm referring to is New York State Education Law, Article 145, Section 7209. In pertinent part states, no official of this state or any city or county, town, or village therein charged with the enforcement of laws, ordinances, or regulations shall accept or approve any plan specifications or geologic drawings or reports that are not stamped with the seal of an architect or professional engineer or land surveyor or professional geologist licensed in this state and bearing the authorized facsimile of signatures of the licensed professional. You can hand this exhibit up as well. It's 5.
Yes.
I think I have 2 of them here.
You guys need an extra?
I got one.
These are flyers published by the New York State Association of Professional Land Surveyors, for the record.
I would just note that it's not a full quotation of the statute, which I have in front of me. I'll provide that to the board.
So the answer to the previous question of, do we include that Article 145 warning on official reports? The answer is yes, as required by law. If something is not a final document, we include that.
Have you ever seen one of these posters? Or flyers, I should
Yes.
say?
Yep.
Does the MAPA report titled Ridgeline bear the warning and/or seal prescribed by the New York State Education Law, Section 145, 7209?
This one again? Exhibit 2?
Exhibit 2, excuse me.
No, it does not.
What is in your report?
So you have in front of you 2 exhibits. Essentially what they're depicting is the USGS base map. Then it has the ridgeline map overlaid on that. And on top of that, it has all of the USGS contour information above 500 feet. So the solid, it's obviously not very clear on that because it's small, but if you direct your attention to the bigger map, the solid black line outline is the 500-foot contour. So,
You're referring to the second page of your, by the first page?
yeah, both pages have the same thing. One just is zoomed in.
Anything further, Counselor?
The chairman seems to be reviewing.
No, I'm just trying to identify the black line as you
Yeah, it's not super clear on that, unfortunately, just because of the scale. Again, if you're able to see it here, it's essentially the boundary of all the topography.
What is a hill?
So we just put in the USGS kind of stipulation here. So I'm just going to read the quote from their website. The U.S. Board on Geographic Names once stated that the difference between a hill and a mountain was 1,000 feet of local relief, but this was abandoned in the early 1970s. Broad agreement on such questions is essentially impossible, which is why there are no official feature classification standards. So essentially it's saying it's ambiguous. What a hill is kind of up for personal interpretation.
Understanding that a hill cannot be defined, how would you determine the highest point that we need to establish?
So usually we would look at, so if you want to look at the map or this map, you would look for the highest elevation contour that's closed and descending on all sides. So if, for example, and I apologize for the quality of the map. It's obviously not super clear. But if you look, say, at this, it's clear that this is the highest point. Because, I mean, you look at the scale down here, you'll see that the elevation is 1,300 plus. And obviously it comes to a point somewhere in the middle there. So that's generally speaking, that's how it's determined.
Can a high point of a hill be within a larger hill?
Yeah, frequently that happens.
How so?
Essentially, you have an aggregation of hills. As you can see on this map, there's a bunch of smaller high points within what could be considered a larger hill or mountain.
How would you determine the highest point of a hill or range or ridgeline?
So yeah, for this example, the highest point of this aggregation of hills would be that red area, which would be the highest point.
So the highest point would be the top of all the aggregate hills.
Right.
How would you identify where one hill ends and another begins?
So it's hard to define that again because hill's not defined. You know, I think the map seeks to kind of define a hill as a base. There's a base to a hill, the foot of the hill, and then the peak of the hill, which is the highest point. And what the base, the foot of the hill, or the highest point is interpretation.
Does the town code define a base?
Right, so the town code says, but with respect to the ridgeline section overlay zone, that the base of a hill that is of interest is 500 feet or higher.
Utilizing 500 as a minimum elevation to establish a base contour line for any hill, as used in the code. But more specifically, the hill affecting the subject property. Can you illustrate the steps used to identify the highest point of said hill?
Yeah. So again, directing your attention to the map here. This is USGS topography above 500 feet, bounded by that black line, with the ridgeline protection overlay zone map overlaid on there. So what you can see here is that you have a bunch of smaller discrete hills with peaks around 600 to 700 feet. And then as you travel east, you'll obviously see that the grade goes up. So for these, you would say the peak would be around 600 to 700 feet, depending on which hill it is. But it would be the highest point within that hill. So looking at this is a aggregation of hills, the highest point of which is this red area. So if you want to look at the more detailed version of this map, it brings it into clearer relief. The highest point of the hill, which starts down here, the base is 500 feet, as defined in code. The highest point or hilltop would be this elevation, which is Clove Mountain at 1,385 feet.
What is the highest point of the hill of which this subject property sits on?
So again, that's Clove Mountain, 1,385,
Point to it on the map.
shown here on Exhibit 4B, right?
Page 2.
Page 2.
Okay, so in your opinion, your professional opinion, the highest point of the hill for this subject property is 1,385 feet.
Correct.
This may seem a little silly, But can you calculate what elevation would be 200 feet below the highest point of 1385?
That's 1185.
Have you identified the highest point in elevation of the subject property on the reports?
Yes, it's on both maps. It's 510 feet.
What's it up to on the map?
And on the first page, eastern edge of the property.
So just to repeat for the board, the highest elevation of the subject property is
510 feet.
Again, I'm sorry I have to ask a silly question, but we have to put this into the record. Can you confirm that the subject property's highest point of elevation, 510 feet, is not within the 200 feet below the highest point of the hill?
Yes.
In your professional opinion, can you assert with factual certainty that the subject property, based on the criteria in the town's code, does not fall within the boundaries of the town's ridgeline protection overlay zone?
Yes, we believe in our professional opinion that the subject property does not fall within the boundary of the ridgeline zone.
Thank you, Andrew. Does the board have any questions for Andrew?
I will, but I'll allow the board members to go first.
I do have a couple questions.
Sure.
Is, why did you choose this particular aggregation of hills?
Yeah, why Clove Mountain? So you basically picked Clove Mountain as the point to measure from.
Essentially,
Stay close to the mic or carry it with you.
essentially, so the USGS map comes in quadrangles at like a massive scale. So you're looking at a very large area. When you look at USGS's online tool, essentially it puts all that information onto the webpage, and you can see where the contours are for a very large area. So what we did was we kind of looked at the whole region of the property and said, what would be the highest point of the hill, per se, that this property is on? That's kind of how we came to Club Mountain.
Because I was thinking is, would it not be possible, given the essentially scope of your lens on this thing, you can pick up any high point you felt like,
Exactly.
depending on how big a lens you wanted to use.
That's fair. Yeah, that's fair. I think what the definition of the hill that I kind of gave, if we were forced to give a definition of a hill, is descending on all sides. So we're trying to find a point of prominence, I suppose.
But could not a hill have sub-prominences that also meet that criteria?
Yes, yeah, for sure, definitely.
And, as a matter of, from a quantitative point of view, how much prominence would make a hill? Can you have one topo line of 10 feet? Is that a sufficient amount to be a hill?
Right, that's the difficulty in not having a definition of it. So
Okay.
that's where we kind of run into the difficulty of. I think the point that we stuck on was the highest point of a hill greater than 500 feet in height. So we're kind of looking at the whole area and trying to find the highest point on that hill and kind of using 500 feet as the baseline of the entire hill.
But given this very general description or definition of a hill, could not some of these minor prominences from the town's perspective have also been designated as a hill for their purposes?
Yeah, sure, fair. I think we kind of looked at that too, and part of the documentation that the applicant gave you guys when we made the application, I think, showed some profiles, also from the USGS mapping service. And I think those can kind of attest to what you're saying of having the local prominences.
Mm-hmm.
I think you'll see, if you look at those, and if you look at, I can direct your attention back over here really quick. You're gonna see,
Flip it.
so you're gonna see again, Clove Mound's over here, it's 1385. Our property's over here. Eastern boundary of which is around 500, 510. Then if you look at this kind of area, this local area, which you might describe as a local prominence, the highest point in this general area, which is also shown on the profiles that you submitted, is this area right here, I believe, which has an elevation of around 715 or 717. Again, that would fall, that value is higher than the 510 or so that the eastern boundary of the property is at. So however you want, if you want to define it as a local prominence, I guess, I don't know if it necessarily makes a difference. So what he's arguing.
Well, in the absence, since we do not know, at least I don't know, how the town determined their map, whether it's map A or the filed map or whichever map we want to use, then I'll stipulate either one. We don't know how that's determined.
Okay.
This definitional exercise becomes rather critical.
Yeah.
Right. Okay. That was my.
And then, yeah.
So to define a hill, you were using USGS criteria?
Yes, that was the intent.
Okay, but the code doesn't state that USGS defines what the hill, controls the definition of hill, correct?
Yeah, correct.
Okay.
What we were doing is we're saying, we're looking at the definition of a hilltop as defined in the town code.
Mhm.
It's not very clear. So we were looking for other definitions of what a hill is, and USGS pretty much said there is no definition of a hill.
Okay, and are you aware when something's not defined in the code, it's supposed to be given its normal and customary meaning? Under law? Okay. How would you normally or customarily define a hill?
I think my opinion, I'm not going to say, it's not a professional opinion per se,
Mhm.
but normally and customarily I would think of a hill as something that has prominence, like the chairperson said, and rises significantly higher than the surrounding area.
And if I understand your testimony correctly, you indicated that if a map does not have a seal on it, it is not valid under New York State education law. Is that a fair summation?
I believe so.
Okay. And you do work in other communities, correct?
Yeah,
And what communities?
I'm not really at liberty to say that, unfortunately.
Okay. Well, I'll tell you, it's public knowledge. Paggi Engineering does work in the town of Wappinger, correct?
Yes.
Yeah. So I pulled up publicly available zoning map on the town of Wappinger website. I don't see any engineering seal or disclaimer on here. So is it your testimony that the town of Wappinger zoning map is not enforceable?
Yes, you got me in a bit of a pickle there. I'm not the professional engineer that's the principal of the firm, so I can't speak on that, unfortunately.
But if it doesn't have the seal or the disclaimer, that was your testimony, correct?
I mean, yeah, I'm just gonna have to defer that to the applicant or the principal of the firm.
Fair enough. I have no further questions.
Any other questions from the board?
I have just a question. Are you giving testimony on yourself or on behalf of the firm?
On behalf of the firm.
Okay. Please,
Any other questions?
please continue.
I have some general questions for the applicant after this
Okay.
witness is done.
Okay, so just so we're clarifying, the chairman asked you whether there could be local, sorry. In addition to the hill that you identified as the top of the hill closed mountain, there could be other more localized hills, correct? And based on your analysis, even if we use those localized hills, would this property fall within the 200-foot boundary?
No, as we talked about, the local high point or prominence is around 777 feet in elevation, as shown on the exhibits that you submitted, profile exhibits.
And the elevation of the subject property is outside of that limit?
Correct.
I have no further questions.
Anything else the board would like to ask?
Not at this time.
One thing I would state is I would like this witness to be available at any adjourned hearing of this in the event the town presents its own consultant to review this. I think it would be helpful for any follow-up questions.
That's it.
That's fair.
And this is becoming a rather, involved matter, so you're not going to be, we will not be rendering a decision this evening.
Mr. Chairman, just from my own, I spent more time reviewing the history, the data, the analysis on this ridgeline code and this particular application than I think I've spent on any other application in my entire life. It was so detailed, and I certainly understand and would join that the board retained a consultant to review the data as well. I think it would be very helpful.
That will probably be one of our next acts. Are you complete?
I can conclude just so we make sure, are there any other questions for Andrew?
Not for me.
No, and I have a couple more, but I need to look at his exhibit in detail, and I don't want to take that time right now.
Thank you, everyone.
Thank you.
All right, so I think I can conclude. I would just like to add, zoning ordinances are in derogation of common law. They must be strictly construed against the municipality that drafted them. And any ambiguity that may exist must be resolved in favor of the property owner. I think we'll conclude. Does anybody from the audience?
Well,
Well, I have-
No, not yet.
Yeah.
We'll engender their comments. when we're done here.
Does the board have questions for the applicant?
Yes, yes. Thank you. Any specific for the applicant at this time? And you have any additional?
I do. My understanding of your presentation is that you believe the reliance on the USGS is improper because of disclaimers that they make themselves.
It may in fact be.
But isn't the town at liberty to adopt itself information that it wishes to rely on and use that as parameters in its local law?
I'm in no position to tell the town what to do or what not to do.
A number of your comments in the presentation were that definitions and other things should be disregarded as overly broad. But doesn't that get into a facial challenge beyond what the ZBA's scope is? Because the ZBA is to give meaning to the intent of the full code.
Having spent quite a bit of time reviewing this, I think I understand where your question is headed. And I think I share your concern that
I'm not saying it's a concern. I'm just saying, wouldn't it be more appropriate in a legal challenge for a court of law?
pursuant to the code, we're here for this zoning board to determine uncertainty as to the boundary of the ridgeline code. Could, in fact, there be issues that the town board can resolve? Perhaps. If this board wishes to refer some matters to the town board, that's their prerogative. We may actually join those applications. We are particularly concerned about major portions of this code. Serious concerns.
And let me just go back to my notes here.
I'll add one additional item. This particular code has affected quite a few people. It's very expensive and causes quite a bit of delay. And I think it's in all of our interests to get this thing right, at least for the property owners that are affected by it, for their sake. I think they at least deserve that.
And I would ask for the submission of any case law that zoning maps fall within that section of the education law that you
We're not going to
cited.
provide any case law,
You're not going to provide case law.
no.
So,
We generally, just as a general rule, we do not provide case law to zoning boards as a general rule. That is the policy of our firm.
I would take that as the applicant being uncooperative to our request to support their positions with legal arguments, and I think you can make a fair inference with that. I will obviously advise the board accordingly. Having practiced land use for many decades, there's really no logical reason behind such a position.
Anything further?
I believe the chair, you wanted to indicate a 5-minute time limit on comments this evening?
Yes, I'm at this point, and could you move the exhibit?
Yes. We want to leave it?
Yes, leave it
We can
over.
move it to the side.
Either side, so it's visible by both.
You pick.
You pick whichever side you want to go to. At this time, I'd like to open the public hearing to comments from the public. Couple stipulations. It behooves us to, all comments should be civil. All comments should be relevant to this particular application. All comments hopefully should not repeat themselves nor be redundant in the, scope of having, timely listening to the various comments. I'd like to stipulate, unless it comes up that the commenters limit themselves to 5 minutes. I think you should be able to make your point within 5 minutes. So at that time, is there anybody from the audience that would like to come up and speak? Please come up, state your name into the microphone.
My name's Thomas Carley. I just got a couple questions. If when we do work in your town and I gotta provide you stamp plans to do anything in your town, how do you not operate off of stamp plans to tax me or ask for fees?
This board is not the taxing
I'm just
entity.
putting that out there. So like, that's kind of contradictory in your own town, no?
So the question would be whether or not it's legally required in a zoning
Well,
code.
if you can just tax my property or just collect fees based on an arbitrary, we're just throwing watercolors over a map here, but I can't build a deck without stamp plans. Kind of ridiculous, no?
I don't think we need to respond to the question.
Yeah, I wouldn't respond to that either.
It makes a lot of assumptions that are factually inaccurate because an engineer did prepare it, so.
Bridge line, one topography line, define a hill, by this 500 feet, then clearly not, right? No, not even close,
Group.
not even close.
Please keep your comments to the board.
Do we need to, okay, so you're saying,
I'm just listening to some of these things here and they just don't make sense at all, so I just want to point them out as well.
Sorry, what was your name again?
Thomas Carley.
Thomas Carley.
Nope.
okay, anything for,
Yeah, I mean, if there's no definition of a hill, but you guys are gonna claim 500, one topography line doesn't cover. We do a lot of business in your town, used to, it's very difficult now. We've had jobs shut down, permits shut down because of this whole ridgeline business, so it's clearly a problem. I don't understand how we're just blanketing this and gotten away from it till now people, it's like enough is enough around here. That's really all I have to say. Honestly, those two things are absolutely ridiculous. We have to abide by state stamp plans, engineered stamp plans, but you guys can just throw watercolors over something. That's like absolutely insane.
Thank you. Any additional comments?
I have two questions.
Please come up.
Please come up to the microphone so it's on the record.
My name is Kamal Mohammed. On the first question, the applicant stated that many hours were spent. Can we have an idea as to how many hours those were
I think he's talking about.
for analysis
Yeah.
purpose?
No, he's talking about.
He's talking about his own work,
His
not
work,
town
his
work.
work
Okay, no, his work.
Mm-hmm.
in reviewing
made
the
a
various
statement
pieces of
that-
town code, et cetera.
Yes, he made a statement that many hours were spent. I don't know, and the board doesn't know how many hours were spent on the analysis. And the second question, it seemed, well, I make a comment first, then I ask question. It seems that the USGS information runs into definitional problems, like the town code that the applicant is claiming. The applicant made a lot of comments about broad definitions in town school. The same problems seems to happen with the USGS information, and assumptions go into them too. So those are my comments. Thank you very much.
Thank you. Any further comments from the public at this time? Okay, it's my feeling we've been presented with a lot of material.
I have one last question.
Please come back up to the
Back up,
microphone.
it has to be on the record, sorry.
No, it's fine. So this gets referred back, what is the decision process in the final? How does this go? You guys get to go behind closed doors and like make your own ruling? Or how does this, who decides on this?
No, we will, you know, where I was headed on this thing is, we're gonna go back, we have things to look at here. We have to, you know, I myself would like to review these particular exhibits in somewhat more detail than the paper given to us. I mean, I know this is all online, I can do a number of that.
Sure.
We also would like to approach the town and request that they provide us their expert or whomever they used to prepare this map and also look at the material. Because I believe that, you know, they have retained their own professionals in that regard. So it's very likely that, you know, they may come back here at a subsequent meeting to talk about what their view of the map is. And then, so those are some of the things that I would believe individuals on the board would take into. There will be we don't have any secret meetings.
No,
per se.
just, you made a thing about this won't be made tonight, we'll talk and other people be involved, so I just wanted some elaboration on that.
I mean, we may, you know, consult with our attorney on some of the matters of law in
Yep.
regards to this, but once again, the decision and the decision process will be in a public forum, a meeting yet to be determined.
Okay.
I would ask the applicant to consider preparing a synopsis of the presentation made this evening with the exhibits because, I mean, even with variances, we ask applicants to support it with writing, and this is quite a bit of information. There's not a stenographer here tonight, so we have to rely on the reliability of the video to the extent it was able to pick up all the voices.
Ms. Walker is actually making the point I was about to make. I'm assuming we're closing the public hearing?
No.
We're gonna adjourn it.
You're gonna adjourn it. Okay, so we can we can make a written submission.
Correct.
To the
We
board.
will accept written comments and written submission until we, you know, continue the public hearing at our next meeting. That's my intent.
Ms. Walker, you can certainly call me, just so we're clear as to
So I will email you to schedule you a time. My office, you cannot reach me directly from the phone line. I had to do that for security reasons. So I have to make a lot of phone calls from my cell phone, which I'm not at liberty, so I will use a block number when I call. I'm happy to schedule a time with you to talk.
Just so we can review the specific information, so there's no, anything missing, no ambiguities. We have enough ambiguities to deal with here. Let's not create our own new ones. So we'll keep the record open. That's actually a relief for me, because I think there there's a couple of exhibits which I just didn't have. I would like to return them in.
Yeah, we would welcome that. I would just ask if, because I would suspect that any engineer that is retained, and it likely would be the engineer who has worked for the town to describe the mapping, would need to come in and present his own testimony, and he's going to need time to review this information. So are you able to submit that 2 weeks before the next meeting, which would be roughly 2 weeks from now?
Sandy,
So
when would
March
I be?
16th is the deadline.
March 16th? Okay.
Correct.
Repeat that. I went too
So in
fast.
other words, I want whatever consultant the ZBA is going to be using, which I anticipate it's going to be the prior engineer from the town, who still is consulting on a number of matters. He's going to need time to review the video and your submission. It's most likely going to be Greg Bolner, I would expect. And because he has been with the town over 20 years and likely was intimately involved with the mapping. So I would like that opportunity for him to review that information so that he is able to give a response to the information that was
Okay.
presented.
Will we have an opportunity to review whoever this engineer's report is, to review that report as well?
He will come in as a witness as well,
Okay.
because you do have the right, yeah,
I would expect him to be here at our.
And we could cross-examine.
yeah.
Yes.
And assuming he's available, that might be the other,
Whoever it is.
yeah.
Um,
Well, available on April, whatever the next, yeah, I mean, if he's not available, that may cause another wrinkle.
Okay, so now, our submission, let's just be clear on that. You'd like us to make a submission, or we'll just do that in a phone call?
Yeah, but we'd like it by March 16th so that we have time to review it and our expert.
So that's 2 weeks,
March 16th.
2 weeks.
2 weeks from
And I-
today?
Yes.
Yes, and along with the hard copies, whatever, to avoid when you ask to use the system, you need to send me that digital of whatever you want presented.
Are we going to be on Muni Collab by then?
I won't know until Thursday. I'm not.
Okay.
I'm not quite sure.
Just so you understand the question I'm asking, the town is moving to a company known as Muni Collab, where applications will be
Unfamiliar.
posted up there and they essentially live up there, where you don't have to go back to prior meetings.
Digital submissions?
Yeah,
Yeah.
that's why I was asking if we
I'm
were
very-
transitioning yet, yeah.
I'm very familiar with those.
Yeah.
Okay, I think that's it for tonight. Any other questions?
No, well,
Okay.
anything from?
Any board members that have questions?
At that point, I would like to, I'll take a motion to adjourn.
So moved.
All in favor? Okay,
Second.
fair?
I-
Okay, this meeting is adjourned.
Thank you, Mr. Chairman. Have a nice evening.